Welcome. Thanks for coming by on your lunch hour. This is a special occasion for Inskid and for me personally to welcome back to campus a dear friend and colleague, Professor Rod Smolla. Rod is now visiting at Duke Law School as a member of the law faculty there, and previously, I guess over the last couple of decades, Rod has held a number of senior positions, most recently as President of Furman University in Greenville, South Carolina. Prior to that, he was Dean and Roy Steinheimer Professor of Law at Washington and Lee School of Law. Prior to that, Dean and Allen Professor at the University of Richmond School of Law, and prior to that, and I think when we first started working together, Director of the Institute of Bill of Rights at William and Mary School of Law. Rod is a nationally recognized scholar, teacher, advocate, writer, and one of the nation's foremost experts on issues relating to freedom of speech, academic freedom, and freedom of the press. During his legal career, Rod has presented arguments in state and federal courts all around the United States, including in the United States Supreme Court. He's also testified before committees of the United States Senate and House of Representatives. He's a prolific author. His books are amazing. His book, Free Speech in an Open Society, in the 90s won the William Douglas Award as the year's best monograph on freedom of expression. He's also the author of Jerry Falwell versus Larry Flynt, the First Amendment on Trial, and another one called Deliberate Intent. This one I was particularly jealous of because Deliberate Intent was made into a television movie by FX, and Timothy Hutton played the role of Rodney Smolla, depicting his involvement in a notorious case in which Rod successfully represented the families of 3 murder victims in a suit against the publisher of a murder instruction manual. Smolla's latest book, The Constitution Goes to College, describes the constitutional principles and ideas that have shaped American higher education. I can't help but mention in passing that he's also the co-author of an amazingly good constitutional law casebook called Structure and Rights in Our Federal System. Rod, welcome to Syracuse.
Thanks. Well, thank you all for taking time today to come and listen to me. As I was preparing for this talk, happened to think of a few lines from a man named Will Rogers. Now, most of you have no idea who that is. A few of you might. He was a vaudeville entertainer and American storyteller and comic in the 20s and 30s, long before the digital world that we have. And was a very, very funny person. And someone once asked Will Rogers, how do you write your jokes? And his answer was, oh, I don't tell jokes. I just watch the government and report the facts. He also once said, you know, it's actually a good thing we don't get all the government we pay for. I was thinking about those lines because as a person talking about the new world of massive online leaks, or a law professor like Bill inventing clever exam questions regarding those things, you don't have to tell jokes. All you got to do is watch the government report the facts. And I wouldn't be surprised if at least some folks in the room would be perfectly pleased that some government agencies, maybe the National Security Administration, they'd be happy if we didn't get all the government we pay for in light of the massiveness of the recent surveillance that has been revealed in some of the recent leaks. What I'd like to do is talk to you a bit about some of the ethical and practical and legal questions that surround that world of leaks. One other thing I'll tell you, it's always good, I just got here a few minutes ago, and it's always good when you're going to talk to folks, I think, to do some intelligence in advance on your audience and the culture that you're entering into. And usually, of course, the best way to gather that intelligence is from your cab driver. But I didn't have a cab driver. Instead, I had a law student who I think is on his way here. I don't think he quite made it yet because of parking restrictions, but supposedly sometime the next day or two he'll find a parking spot and make it. But I asked him a little bit about the topic, and it turns out that he, before he came to Syracuse Law School, worked on the Hill for a congresswoman from Florida, and she was at one point chair of the House Foreign Relations Committee. And the instructions to him, working on the Hill as a staffer, were that it was impermissible to read leaked material. So he was not allowed to go on WikiLeaks, he said, to read the leaked material. And even to read the quotations from WikiLeaks in the New York Times or the Washington Post was frowned upon. And I said, was the perception that this was unpatriotic or inappropriate for you, a federal employee working for the Congress, to do this, or that it was actually illegal? And he was a little fuzzy on exactly where it was, but he didn't read it. He didn't read it, you know. So I'm going to use that to open this discussion with two hypothetical questions that I'll ask you. And I'll ask you to kind of hold the thought on them, and then when we get to discuss this a little bit in a few minutes, maybe you'll have some answers to them. I know some of you are law students, many of you are not, but some of you either have in the past or at some point in the future may someday work for the United States government and may someday work in a capacity where you would have access to classified materials and may, in fact, be helping to form policy or give advice with regard to classified material. And so my question is, can any of you imagine that you would ever deem it morally appropriate and you would, I suppose, hope also legally defensible to leak classified national security material? Can any of you ever imagine doing that? Would you ever do it? Or is it unthinkable that at any time in your life you would ever do what Edward Snowden did or anyone else did and actually leak to those not authorized to receive it classified national security material? It's a really interesting question. For those of you who are law students, you actually have a double ethical filter you've got to work yourself through here, because you also would be government lawyers, and and your access to the material is presumptively covered by various obligations of confidentiality, wholly aside from whatever the national security regime imposes on you. And so in that double role, as a lawyer trafficking in national security material, would you ever deem it ethically permissible to leak the material, and would you ever be moved to do it? I know we also have a number of folks here from Newhouse, and people have had careers in journalism and have taught journalism students over the years. And so I want to ask you a second hypothetical, but those of you that think of yourselves as national security gurus or lawyers, you can participate in this one as well. Imagine you are journalists, or you are working on behalf of journalists. You're advising journalists on ethical issues or legal issues. And you come into possession of national security material leaked to you. So you are the leakee, not the leaker. And the material clearly would be of interest to your viewers or your readers. And it in your view, it has a quality of newsworthiness to it. Would you always publish that material? Would you ever think of not publishing the material? Would you feel an ethical presumption that it is your duty in that role to publish the material? Or would there be moments in which you would deem it ethically inappropriate to publish the material? Would any of you in that role ever think you might actually be violating the law in publishing the material? We obviously have at least one person in this community who thinks to read it might be illegal, or at least was told that, but you're in the position of trying to decide whether you think there's ever any restraint on you, ethical or legal, in publishing the material. So those are the questions I want us to ponder. If we had, and I'm sure in our discussion some of this will come out, if this was a law school class I was teaching, and perhaps if it were a journalism class I was teaching, one of the first things we'd probably try to do is conjure up the various policy issues and philosophical issues that tend to support the idea that it is okay in some instances to either leak material, and certainly okay in many instances to publish the material. And then we try to conjure up the counter-arguments on the other side. And I'm sure many of these are swirling through your heads already, but let me just try to tick through a few very, very quickly on each side, so we have those out. and then I'm going to walk through with you a way of thinking about the problem, and then we'll discuss it openly. So the pro-leak position, if you will, the position of those that may defend the actions of persons such as Edward Snowden, or certainly defend the actions of those who publish that material, Der Spiegel, the New York Times, The Guardian, WikiLeaks itself, and so on. I think that case goes something like this. There's the argument that we live in a culture and we have a government that massively over-classifies material. There is way too much that is classified, and much that is classified ought not be if you believe in a transparent and open government and democracy. Secondly, we know, largely because of the leaks, that we live in an extraordinary surveillance state, that at least in terms of its breadth and perhaps in terms of its depth, the sheer amount of surveillance that the government undertakes today in light of national security is frightening and is itself a threat to our conceptions of liberty and autonomy. Third, that ordinary channels of protest against overclassification or the surveillance state are largely ineffective, that it's terribly frustrating to go through channels to protest these regimes and likely to not get you anywhere. Just this summer, the United States Supreme Court denied standing to a group of lawyers and journalists and activists that sought to challenge a lot of the surveillance regime on the theory that their interactions with persons who might be targets of some of these investigations would chill the exercise of their First Amendment activity. And the Supreme Court said you don't have standing. Your theory of harm is too attenuated. So that's an example of the sense of frustration. And then I think the maybe deeper cases, the more morally resonant for some arguments in favor of leaks, are that often the leaker is heroic and sacrificing his or her own well-being, his or her own reputation, his or her own ability to live in the United States for a larger cause, and that larger cause is the exposure of corruption, wrongdoing, misguided government policy. It is a altruistic blow for freedom, an act of civil disobedience perhaps there's no legal defense, but morally admirable, and there might in some situations, it might almost be in some people's minds morally compelled to blow the whistle on this wrongdoing. And then as an adjunct to that, there are very well-respected people around the country who argue that from that there must derive some legal defense, certainly a legal defense for those who publish the material, and that's relatively easy to construct and is probably the leader in the argument from a legal perspective. But arguably, this is a little more radical, a little more problematic, but arguably at some point perhaps legal defenses for the leaker that ought to be brought to bear, either defenses that already exist or that ought to be understood, read into statutes or read into First Amendment doctrine, for example. So that's the case on one side. Case on the other side is, it's funny how this works, sort of the flip of everything. The case on the other side begins with the supposition that it is a very, very dangerous world. That there are many people, particularly those of you like me that love homeland, all right, there's many people that are out to do the United States and freedom-loving peoples around the world in, that have no respect for the rule of law, that have demonized our culture and are out to destroy it. And the fact that we haven't had a catastrophic episode of terrorism like 9/11 doesn't mean they're not trying. Secondly, that the massive surveillance that we undertake and the extraordinary technologies that are now brought to bear to organize and collate and analyze that surveillance, that's a good thing. That is a brilliant weapon that we have. We're fortunate to have the software ingenuity and the technology to intercept all of this material, and people that are willing to go to work and do the hard work it takes to analyze it, and that makes us all safe. That's where the war is now, and that's a good thing. Thirdly, that it's a caricature. It's paranoid. It's so I don't know. It's so George Orwell, to be worried about civil liberties being lost, because these are good people with a sense of the balance between freedom and security, a sense of the importance of drawing the line between real enemies and spying on people that are ordinary citizens going about their business, that there are conscientious federal judges, often some of the most distinguished federal judges in the country on the FISA court, that they take their job seriously, that they're not a rubber stamp. The reason they have such a high approval rate is that they and their staffs negotiate the problematic cases and work out better systems before they reach the FISA court. And so that's an exaggerated claim of paranoia. And then on this side, it gets deep too. On this side it gets deep, because the moral position that will often be brought to bear is, what do you think it means to go to work for the United States government in a national security role? What do you think it means to be a lawyer? My goodness, when you're a lawyer, you're entrusted with people's secrets. You don't have the right to say, I don't like what you're doing, I'm going to go walk and tell the New York Times everything you've just told me. And the whole idea of being a fiduciary, the whole idea of signing an agreement that promises you won't publish material, the whole idea of the rule of law is that you don't take it to the street. You don't take it to some Julian Assange. You take it through the channels. You abide by the apparatus that society has created. You don't have the right unilaterally to decide, I think this is stupid policy, and I'm going to blow the whistle on it. There are people elected to do that, and you're a kind of vigilante in taking the law into your own hands and presuming to make these decisions. And you're actually a thief. You don't own this material, and you're stealing it. You're stealing it from the government. You're stealing it from society, and that was what Richard Nixon said of Daniel Ellsberg. He called him a son of a bitch and thief. That's that, and I believe he meant it exactly in those literal terms, and this side of the coin will say, and the righteousness, the free press, free speech certitude with which so many journalists feel reflexively it is their duty to simply say, is this newsworthy? All right, we're going to write it, and maybe occasionally not publish something because they can tell it's dangerous, but feeling that of course their role as citizens is to publish, and that the First Amendment is essentially an absolute immunity to any liability for that publication. That is a misguided position. That it's a misconception of the actual legal rules, and it's a misconception of First Amendment principles, and it's very ethically problematic, because in most places in our society, if you receive stolen goods and you knowingly traffic in the stolen goods, the law treats you as also worthy of condemnation and sometimes a criminal, and that's what you're doing. So those are I'm sure there are people who adhere one way or another to a number of these, and some may be conflicted and crisscrossing. So let me give you very quickly, in about 6 or 7 minutes, a little matrix to help think about this, and then I'll enjoy having a discussion with you. It would be tempting, if you were law students or journalism students and studying for a final exam, it would be tempting to have a very simplistic outline of how this works, and it would be very binary. And your basic rule, you'd fill it in a little more to get style points, but your basic rule would be, leakers are always wrong, and they have no protection, and they can be punished and often will be punished. Bradley Manning got 35 years imprisonment as his sentence, okay? And the government has the political will to go after leakers. In the modern era, since Daniel Ellsberg, who was prosecuted twice, both kind of got botched, but he was prosecuted twice, right on through, there have been about a dozen significant, famous people that have leaked national security material, and the government has prosecuted virtually all of them, sometimes successfully, sometimes unsuccessfully. Sometimes the prosecutions have died on the vine because the government decided it didn't want to go forward with it. But they'll at least go after leakers, and you could have your life ruined. And Edward Snowden may have his life forever changed because of what he did. So that would be one part of your outline. Leakers always lose. And then the other part of your outline would be, those who publish leaks always win. They're basically in the right, and they never get prosecuted, and they in fact probably can't be legally prosecuted. And you'd be tempted to have that view because that seems to be what history teaches. In fact, the leakers are often prosecuted, but interesting little fact, sort of a constitutional law, national security, a little soundbite you can use to amaze your friends. Never in the history of the United States has there ever been a journalist prosecuted for publishing classified national security information. Not in the history of the United States. Now, there have been a few teases, been a few close ones. Of course, there have been a number of famous instances in which the government tried to restrain the publication of material. Most famous is the Pentagon Papers case. Another famous one called the Progressive involved the publication of material that maybe taught you how to build your own atom bomb. Obviously, if it was that simple, then more people would have atom bombs probably. But those are some famous efforts to restrain publication. But the actual criminal prosecution of publication has never happened. A few close calls. One very famous close call involved the Chicago Tribune, which published the story during World War II that the United States had broken the naval codes of the Japanese in the Pacific War. And this was, the Chicago Tribune then was a very virulent, anti-democratic, pro-Republican newspaper. Its famous publisher was Colonel McCormick, and the Tribune hated Roosevelt. And the sort of story was, you should have known about Pearl Harbor in advance, you'd cracked the codes, and what a disgrace that you didn't stop the invasion. The United States government was beside itself with anger over this. People within the military and within the Department of Justice exchanged memos basically saying we've got to put the Tribune people in jail for this. A Chicago grand jury was actually convened. The Chicago grand jury didn't return an indictment. I grew up in Chicago. There are a lot of explanations for that that are possible. And the Department of Justice then decided to drop the case because it was well past the leak, and the Japanese appeared to still be reading still be using the same code. So the United States decided we'll just be quiet about it. And in fact, apparently the Japanese never figured out that we had the code. I guess there was no one in Japan that were Cubs fans. You know, there was nobody reading the Tribune, and they didn't know. By the way, I'm a White Sox fan, but Mr. Cub, Ernie Banks, got the Medal of Freedom yesterday, presented by another White Sox fan, President Obama. But I grew up going to Wrigley Field because it was much closer to my house and watching Ernie Banks. And I didn't know about the Japanese code. I didn't know that the newspaper that owned the Cubs maybe were traitors. So that was a close call. And that actually led to later revisions of the Espionage Acts in light of that Tribune incident. The only other close call, legally, is a relatively recent case involving the prosecution of some lobbyists for AIPAC, a pro-Israel lobby, who got sources within the government particularly one source, to leak to them classified material, a lot of it involving the Middle East and involving Israel, and then they used that classified material to try to influence journalists and policymakers, members of Congress, and so on. And they were prosecuted as publishers of the national security material. And very long, very thoughtful, very deep district court opinion in that case. The district judge, Judge Ellis, said there's no First Amendment barrier to the prosecution of these people. Now, they weren't journalists, but they were very close to being journalists. They did a lot of the things that journalists do. They cultivate leaks, and then they use the material to disseminate to a broader view to try to influence people's opinions. So that's maybe the one published opinion that comes fairly close. It's one federal district judge, you know, and no appellate decision ever came out of that. If you're struggling with the hypothetical that I gave you at the beginning, I'll give you some thoughts on that, and then I promise I'll finally be quiet. It seems to me that if you were struggling with this, either from the perspective of whether you should ever leak material or the perspective of when you should or shouldn't publish leaked material, that there would be two principal factors, in my view, that would be brought to bear in your decision-making. And the first would be your judgment regarding the level of damage to national security. And the second would be your judgment regarding the newsworthiness of the material. Now I have actually created, in my head at least, a chart. I'm old school, I don't use PowerPoint, I should have for this. A chart. I'm going to suggest to you, you could grade the damage to national security on a 4-point scale, and you could grade the newsworthiness on a 4-point scale. So let me try to do this for you real quickly. On the national security side, we'll start with a 1. And this is material that is classified, but its leaking will cause no damage to national security. There's just no case you can make with a straight face that this was ever going to hurt anybody in any way. That's area 1. All right? Area 2 is the material may damage our military preparedness, may damage our intelligence gathering capability, so it might damage our national security, but in a vague, gauzy, generalized way. Often because it is embarrassing in what it reveals. It would cause more people to hate us. It exposes some ineptitudes. But the thing about stuff in level 2 is that it doesn't reach the level of functionally or operationally damaging national security in any way anybody can explain or point to. So you'll find people in government. You might find somebody like Bill that would say, that hurts us, you know. But it's not a very palpable, functional, operational form of hurt. So that's grade level 2. Then we cross into the bad stuff. Level 3 is where there is a general degrading functionally and operationally of our capacity. But you can't point to a specific operation that's been damaged. You can't point to a specific spy whose identity has been unleashed. You can't say that this particular operation in this particular country has been hurt. But you can say with some confidence and some real believability that in a functional way we are less able to do things that are important to protect ourselves after this leak than before our leak, but it's that general degrading. And then you have level 4. And level 4 is where it's a functional harm, and you can point to specific things that are going to go bad because of it. People may die, agents may be revealed, a planned military operation may have to be scuttled, there may be retaliation against our sources. There's, in some clear, palpable way, you can point to functionality that is damaged, and this could mean people will be killed even because of it. So it's the most extreme form of damage to national security. Now we do the same thing on the newsworthiness side. You first could have material leaked to you, and I think probably some of the material that has been published in WikiLeaks is material in which it is not newsworthy at all. It's maybe a little gossipy, it's maybe a little cutesy, it's maybe a little, your curiosity may be piqued, but there's no newsworthiness. And when I say newsworthiness, by the way, in this context, I'm using a little bit of a narrower conception of newsworthiness than some journalists and others might be attuned to. I'm using newsworthiness in the sense that it sheds some light on government in terms of accountability, transparency, policy debate, etc. The First Amendment has often a broader conception of newsworthiness. It extends to things that are entertaining and so on. But I'm not using it in that terms. I'm using it in a sort of more classic, traditional terms, the classic role of the press in that position. And I'm going to come back to that point in a second. So it's gossip, it doesn't matter. Level 2, it really is fascinating and it is interesting and it is revealing in a serious sense, but it doesn't implicate any accountability. So what's interesting about it is the detail. It's fascinating to know how they captured this terrorist. It's fascinating to know how many helicopters were involved. It's fascinating to know which aircraft carrier they flew from. It's fascinating to know who signed off on various decisions. But there's really no dispute, there's no accountability. We like it, we're fascinated in it for the same reason we love history, for the same reason we love a great spy story, for the same reason we like a military account. We like it because of the detail and what it tells us, but there's no accountability function. Third level of newsworthiness, now we're crossing a line, we're getting into genuine accountability issues. It is newsworthy because a lot of people reading this story won't like what they read. They won't like that the government's doing this. They'll think it's wrong for the government to doing it. It's wasteful. It's bad foreign policy. It's misguided. It's immoral. They think maybe it's illegal or it should be illegal, but it creates real debate. So the Snowden leaks about the massiveness of national security disclosures, the amount of interceptions, the level in which they will follow certain trails, is a level 3 leak, in my view. I think there are Snowden leaks probably at 1, 2, and 3, at least from what I can tell, but that's probably a level 3, in that very serious people really think that things ought to be changed in light of what was revealed there. And then level 4 on the newsworthiness scale is not that it reveals stuff that a lot of people are going to be disgusted by and have problems with. It reveals stuff that is plainly illegal, that is plainly wrong, plainly criminal. It shows you that a prisoner of war or an enemy combatant in captivity and shackled is summarily shot by an American soldier. A war crime, a murder, so it reveals real wrongdoing and has the highest level of newsworthiness, arguably. Now, my hypothesis is, if you're doing the math here, there are actually 16 possible combinations, right? And you may think, well, it's going to collate in some way. So the stuff that's not very newsworthy is also going to be not any very much damage to national security, but not necessarily. My theory is any of the 4 on one side could match up with any of the 4 on the other side. And I'll try to give you a quick example. Imagine a Sunday New York Times comes out. There could be stories based on leaks that would reach all 4 levels of newsworthiness. So maybe there's a story in the fashion section that shows you what Michelle Obama was wearing when she was a guest at a private state dinner inside the Kremlin. And it in a catty way, sort of disses her dress, Second, there's a story that gives a riveting account based on leaks of a recent successful hostage rescue. Everybody loves the hostage rescue. Nobody's against it. There's no accountability. There's nothing like that. It's just fascinating to watch it happen. Sort of like the Captain Phillips, account. We're drawn to just the drama of how they rescued the people from the pilots. Then there's a really thoughtful, long, analytic piece. There was one of these in the New York Times 2 Sundays ago, I think, looking at all the national security leaks and analyzing whether we have a runaway agency and whether, illegal or illegal, this is crazy. So it's a serious level 3 piece of newsworthiness. And then there's one taking a classified photo, and the classified photo shows an American official engaged in an act of torturing someone or murdering someone, so it reaches level 4. Now, if you're the New York Times, and if you're a First Amendment lawyer, you'd probably say all 4 are newsworthy in the way we use that phrase in First Amendment doctrine. They're all matters of general concern, and in fact, there's a large First Amendment tradition in cases that says, and it's not the government's business to tell the New York Times which of those stories it should publish or not publish. It is possible that the apparently most banal story, the trivial story about Michelle Obama's dress, it is possible it could be the worst in terms of the national security leak, because what if the Russians are able to figure out, and we're able to figure out, that whoever got that picture had to be a spy close to Putin who was sending stuff to the United States. And they figured out the process of elimination. That's the only way that picture could have been taken. Well, that's a classic example. This happens in a lot of the cases where it's not so much the substance of what's leaked, but the intelligence gathering capacity that is leaked. And if that happened to be someone who could die because of it, or a current operation, our most important intelligence asset compromised, you'd have level 1 newsworthiness, but you'd be at DEFCON 4 in terms of the national security damage, all right? Now, I'm going to end with this. The law students in the room, the lawyers in the room are processing this, I'm sure, and they're saying, so this shows me how maybe morally there might be a position where I could actually understand why somebody would leak, because if it was really corrupt wrongdoing, criminal misbehavior, and they didn't think that it was going to cause serious damage to national security, then you might feel, even though you may go to jail, it'd be morally appropriate to leak it. And my goodness, you'd be thinking probably protected by the First Amendment to publish it. But you're also probably acquainted, if you've taken any First Amendment courses, in a long-standing principle, has a number of nicknames. A lot of times First Amendment lawyers and journalists call it the Daily Mail principle, after a famous case that, involving the Daily Mail newspaper. And the principle is very easy to state. It is that the First Amendment protects the publication of truthful material lawfully obtained. And the understanding among many folks for a long time has been this is why we can't prosecute the New York Times or the Guardian or WikiLeaks, because if the journalist, whether it's WikiLeaks or the Times, receives the information and the information is truthful and the journalist has broken no law in the receipt of the information, the First Amendment protects its broader dissemination to the public, all right? And there have been maybe half a dozen Supreme Court cases that have articulated this principle. I'm going to leave you with the thought that it's not what it's cracked up to be, and that it is by no means clear that the First Amendment would protect publishers, at least in certain parts of that matrix that I gave to you. The lead case, the most significant case in this line of Supreme Court cases is a case called Bart Nikki versus Bopper. Bopper is the Big Bopper, a radio DJ. What a great name, all right? And Bart Nikki versus Bopper comes out of union disputes in Pennsylvania between school boards and school teachers. And there's a lot of discussion about it, and you know, the teachers are threatening to go on strike and all this. And somebody illegally intercepts a telephone conversation among two of the top union officials, okay? It's illegal under the Guacamole Act of 1917 and every law of the state, every state in the United States, and federal law, and probably most countries, it's actually illegal to intercept somebody else's telephone conversation, right? There's a law against it. It's a crime, right? But somebody did it. It's not that hard. Somebody did it. They then tape recorded the conversation, and they put it in a brown paper bag, because I think all the instruction manuals tell you use a brown paper bag, all right? They put it in a brown paper package, and they leave it on the doorstep of the newspaper in town, and they leave it on the doorstep of the radio station, where the Big Bopper takes it, opens it, plays it, puts it on the air, all right? The union guys sue the newspaper, and they sue the Big Bopper. And the theory is that the law, which happens to be exactly the same way the Espionage Acts are constructed, the law not only makes it a crime to intercept a phone conversation, it makes it a crime to publish the content of a phone conversation once it has been leaked to you. So to traffic in the stolen conversation is also illegal. And so they use that law to sue the journalists. The journalists cite the Daily Mail principle and say, we have the Trumps, you know, rock covers paper, First Amendment wins. You can't get us once we publish the material. Supreme Court decides the case in favor of the journalists on First Amendment grounds. Justice Stevens wrote the opinion. I was just at a great program at the University of Georgia. Justice Stevens was the keynote speaker, 92 years old, still ties a great bow tie, and still is the greatest speaker, entertaining, a perfect gentleman, just was wonderful. But I was kind of there to criticize his case a little, all right? He holds in a kind of fuzzy, not very easy to follow, not very clearly articulated legal doctrine case that the First Amendment protects the journalists. He cites the Daily Mail principle and he says, now, we've never decided whether it's always the case that you have a First Amendment right to publish material that is lawfully obtained. We just decide on these facts there's a First Amendment right to publish the material, okay? But that would seem to make you feel comfortable if you were the New York Times or the Guardian or WikiLeaks in publishing the material. But I think that would be a false sense of comfort. And I know that David McCaw, who is the general counsel for the New York Times, would be concerned. I've seen him say that he is not sure that Bart Nikki would protect the Times for a lot of what it publishes. Here's why. Here's the soft spots in the case. First soft spot is it's not a national security case. It's these two guys talking about union stuff. So even though it may be a compelling interest to protect the privacy of phone conversations, the government can lay a lot more stuff on leaking national security material. It's a much higher gravity, so the harm is much, much worse. Secondly, Bart Nikki's one of those curious cases that when you actually count the votes are a little more not as clean as it's often reported to be. It may look on the surface like a 6-3 win for the journalists, but it turns out there are two concurring opinions in the case Justice Breyer and Sandra Day O'Connor. And the opinion by Justice Breyer, joined by O'Connor, makes the actual vote 4-2-3. And they say, we would often side with the person whose cell phone conversation was intercepted. We think it's terrible to report people's cell phone conversations, and we think there's a compelling interest in not allowing trafficking in that, and we think the privacy interests there will often win. But in this case, this conversation revealed that these people were thinking about doing something criminal. And only because the revelation involved criminal wrongdoing, remember my chart, this would be that level where you have criminal wrongdoing, only because of that do we hold in this case that the First Amendment protects the leakers. Now I have to tell you as an aside, I think it was a little shaky that the phone conversation really involved criminal wrongdoing. You know, again, I grew up in Chicago. This was union talk. You know, like what they're saying to each other. Well, if they don't give us a raise, we may have to blow up some porches. You know, but I don't know. It was really a contemplating a crime. You know, but Justice Breyer, Justice O'Connor, and Justice O'Connor didn't come from a union state. You know, so that it was possibly a crime. All right. So that makes the ruling much more ambivalent. Finally, and I apologize for going so long, finally, this was a brown paper bag case, right? It really was a brown paper bag, all right? So the idea that the journalists were totally passive, that they just received the leak, and that's all they did, was plausible. And all the cases have come up in that context. You don't do anything to seduce the leaker, you don't do anything to cultivate the leaker, you don't do anything to facilitate the leak, you're not in any way a collaborator in the leaking process, you're truly passive. But the world we live in now doesn't appear to follow that pattern. And as the journalist becomes more injective proactively in cultivating the source, the journalist begins to look just like the spy cultivating a source. And there have been some fascinating cases, and I'll give you two quick ones. The Fox bureau chief of the Washington Bureau, a man named Risen, is still under investigation for leaks involving Korea. And Risen sent to his source emails. You got to meet in a parking garage for this. I don't think you're not supposed to use emails. Right? He sent.
Rosen, right? Risen.
No, there's Rosens and there's Risen. Is this Rosen? There's two Rosen. This is Rosen. Okay, because all right. Right, Risen is the Times guy that is the Fourth Circuit is, and then there's Rosen, who's one of the APAC guys, I think. All right, my mistake. Thanks for. So the Fox guy says, I would really like to see some classified material here, some internal analysts, if you've got it. And then he sets up a secret code mechanism for how to communicate with the source. And that begins to look a lot less like getting the material in a brown paper bag. And clearly, the more you are in kind of cahoots with your source, the more problematic that will be. And WikiLeaks or other sites that facilitate that sort of leaking by helping you with the anonymity of it and so on can be complicit. In a different arena of law, there is a thing called the Communications Decency Act that generally immunizes internet providers for the content of what they get. But there's a Ninth Circuit case that says if your website encourages the illegal activity in some way, you have a drop-down menu of the various things that you can do, and those drop-down menus maybe violate the Fair Housing Act, then you lose your immunity. Well, there may be some of that. And it isn't just WikiLeaks. In the Snowden leaks and a number of the leaks, it really appears to be a multi-party deal. And the source comes, and then there's an agreement between the source, the New York Times, Der Spiegel, and the Guardian. And it is agreed, there's an embargo. It's like first serial rights in publishing stuff. There's an embargo, so the Times agrees it will not publish the material until a day after WikiLeaks first puts it up. And there is really a sense of collusion among these various parties to the transaction, which puts a lot of pressure on that Daily Mail principle. I'll stop for questions, and if we run out of time, I'll be happy to hang around with anybody afterwards that wants to talk.
This was tremendous.
Oh, thanks.
You field your own questions?
Yeah, questions, concerns, observations? Yes?
Concerning Rosa,
Yeah.
it sounds like you're arguing the case to criminalize the profession of journalism.
Okay, here's what I'd say, that, most professions have tensions built into them as to what it's permitted to do and not to do. So a lawyer in the representation of his or her client can't do everything on behalf of a client that he or she would want to do. There are going to be ethical restraints backed up by the force of law that may prevent me from doing everything I would otherwise want to do on behalf of my client. And arguably, that should both be a professional norm and a legal norm. So I doubt the profession of journalism or the law would countenance actually breaking into a building and rifling through files and picking a lock and extracting very highly newsworthy material. Traditionally, First Amendment doctrine would say that neutral law of general applicability, the law of trespass, the laws relating to intellectual property, laws relating to that kind of intrusion, though understandable because they advance the people's right to know and the mission of the journalist and accountability, cross a line. And so what I'm exploring with you as to where the line is. And I'm suggesting it's easy to say that affirmative physical law breaking, I break into a federal agency's office and extract the material. There might be journalists that would defend that, but I doubt there'd be many. And I don't think any courts will find sympathy. The truly passive receipt of of information puts the journalist on the highest level of protection, though we can explore whether I think that's absolute. But I'm suggesting there may be certain intermediate grounds that cross the line. They may not be a physical breaking of the law, but you are recruiting someone, in effect, to break the law for you. Okay, go ahead.
But what journalists do is cultivate sources.
Correct.
Journalists don't professionally do what happened in the Chiquita Banana case, where a journalist from the Cincinnati Enquirer broke into the phone mail system at the Chiquita Banana Company. He was caught, prosecuted, nobody defended that action. So you're creating a straw man with that sort of behavior.
Yeah.
But what journalists do is cultivate sources. Otherwise, you're arguing that what journalists should do is sit in their offices and wait
Yep. And so
for
I think
information to come to them.
Okay, so I do think there's a real disagreement, because I certainly agree with what you said 80% of the time. But I guess what you're hearing from me is I believe there's both a moral case and conceivably no First Amendment defense for let's take an extreme fact pattern that's good for your side on the one hand and good for my side on the other hand. Good for your side is what the journalist does is the journalist wants revealed material that will have a high level of newsworthiness because of its exposure of troubling, perhaps illegal activity. So that's the journalist's effort. But it will cause high damage to national security. It will, in fact, endanger an existing operation. Now, it's a fair point to say that never happens, that there is a self-restraint on behalf of journalists that prevents them from ever going that far. And maybe that's true. That's debated. The Chicago Tribune arguably went too far. You will read in most of the recent New York Times pieces, just about everyone, certainly the long piece 2 weeks ago, which I thought was a superb piece, 3/4 of the way down there is a sentence that's in many of the current New York Times pieces on this. And the sentence says, "The Times is in possession of additional material that we have chosen not to publish because we have been told it will damage national security." So that's very admirable. They're saying that they have restraint. But let's imagine hypothetically a case where there's a good solid case for newsworthiness, but the damage to national security is at a high level. It's at a level 4, so give me that, right? And the journalist has affirmatively done what you're talking about, cultivated and encouraged and facilitated someone to break the law by releasing the material to them. In my view, that's not a morally admirable act by that journalist, because that journalist is placing the newsworthiness value of it above the damage to national security and presuming to make that judgment himself or herself. So I'm willing, so this is, we're having a real fuss, I'm willing to say I don't think that's admirable. And I think in a case like that, if it was bad enough, there might be the political will to prosecute. Maybe not, but there might be the political will to prosecute. And I'm suggesting that legal doctrine, the little bit that we have, would not protect the journalist in that situation. And then I'll go farther. This is probably where you really disagree with me. I'll say, and I agree with that legal doctrine. I think that in that extreme position, the First Amendment probably ought not come to the defense. So that's it. So, and you go ahead.
We're obviously on a slippery slope. And once you take that position, then the next step is the journalists
Perhaps.
who are successful in cultivating sources and getting this information. I'm unwilling to allow the government to be the final arbiter of what does or doesn't threaten national security.
Okay. Well, perhaps, and that's, and I'm sure there are a lot of folks that would agree with you. You know, I'd like to think that my 16 boxes helps you stay off the slope, and that you actually could think through logically these two relative harms. But I appreciate your point, and I suspect there are a lot of people that agree with that point, and that don't.
I wanted to ask you about the when you were giving the pro arguments for leaking. You said that the deep insight was the heroics of the leaker.
In the eyes of some folks.
In the eyes of some folks. In terms of judges who are applying the First Amendment, does it matter what they, I mean, you can have some cases like Potter Stewart, who has been a journalist himself, had a very positive view of the press. It seems these days there's more skepticism. Justice Thomas just gave a talk at a Federal Society event, which I never read, because don't read that stuff, it's garbage, you know, I don't engage it. And so the kind of, maybe the dog that's wagging the tail here are these judges' view of the heroics or admiration that they might have for journalism as a whole, not even just leakers.
So I'll give you a short answer, then I'll tell you a story. Quick short answer is there's no doubt in my mind that the perceptions about journalism in the media of judges can't help but influence their decision making on this. That's the short answer. Second is I'd be wary of any caricature that assumes that a large number of Supreme Court justices have that prejudice. There may be some, but a large number. Here's the story real quickly. I was asked to comment on leaked material. The leaked material was furnished to me by Adam Liptak of the New York Times. And it was a memo that it wasn't national security, but it was a confidential memo that Adam Liptak, the reporter from the New York Times, said to me, a law professor, was written by John Roberts, now the Chief Justice of the United States, when he was working in the Justice Department. And it proved that he had a hidden hatred for journalists, and he disagreed with New York Times v. Sullivan, one of the great cases in the history of the First Amendment. Would I comment on the material? And I didn't know for sure what to do, because I'm licensed in Illinois and in Virginia, and I knew this was a document prepared by a lawyer for a client, leaked to a journalist 30 years ago, but I felt morally ambivalent about whether it was permissible for me to read the material. But for whatever reason, I said, all right, Adam, I'll read it. So it was given to me, to Anthony Lewis, and to Steve Stone at the University of Chicago. So I read the material, and it was absolutely crazy, over-the-top, vitriolic hatred of the press and of New York Times v. Sullivan. So I called Adam Liptak back, and I said, if that is what John Roberts thought as a young man, I guarantee he doesn't think that way now, because I have argued cases in front of him, and he's written opinions that I've read, and his thinking has changed 100%. He is a very pro-free speech guy, and maybe this was what he thought of as a 22-year-old conservative activist, but he certainly doesn't think about it now, and you can quote me. And so he quotes me for that proposition. Adam calls me the next day and says, he's virtually crying. He says, I have to apologize. He says, I leaked you material under false pretenses. I says, what, Adam, what are you talking about? He says, well, I gave that leak to you. The leak came to me from Senator Schumer's office. And Senator Schumer said it had been written by John Roberts. But in fact, it turns out John Roberts didn't write it. It was written by a lawyer named Bruce Fein, who's a friend of mine, a right-wing conservative, reactionary, against the press guy. As soon as Adam said it to me, I said, "Oh, Adam, I should have realized that was Bruce Fein's writing. I recognize all the diatribes now, of course." And he was so chagrined. I said, "Don't worry about it. You're going to be fine. You apologize to your readers. It happens to everybody. You'll have a happier day down the road." But I tell you the story because it's sort of my one interface with sort of leaks and how I kind of dealt with it, and I'm not sure I dealt with it the right way. But also shows you the kind of the perilousness of even knowing whether the thing you think you have in your hands is what it purports to be. And it speaks to your question, because of what we now know is that John Roberts is a zealot defender of free speech and free press. Thank you all very much. I'll take some other questions afterwards. I appreciate it.
Maybe out in the hall.
Sure.
Class coming
Okay.
Thanks again for the